Good morning, Your Honors. Carrying to meet on behalf of the appellant, Christy Springer. And we filed an appellate brief based upon a order of dismissal with prejudice at the lower court in Pinellas County regarding, for the purposes, since the parties are both female and they both have the same last name, I'll refer to my client as Christy and the opposing client as Nicole to make it easier for the court's edification. So in this case, Nicole and Christy had a relationship of about 7.5 years. It began in Ohio, at which point, after a few years, Christy had been deployed as a member of the United States Army and had left for 1.5 years to go overseas for an assignment. She returned and continued the relationship with Nicole. During that period of time, and just for the court's application, there was also a 7-year-old child that belonged to Nikki at the time they met. And that child's not involved in here because Christy understands that child is, even though she does have a relationship with the child that's close and significant, she understands she doesn't have any parental rights to that child for obvious reasons. She wasn't involved in the planning or conception of that child or bringing that child into this world and was never an intended parent. And that is our argument here, is that the court, many times the state of Florida, in the statutes and the case law, looks at intention of parents, both biological and non-biological, in order to inure rights to people or to escheat them of rights. And in that respect, we do it constantly when either the state is involved or a private party is involved in escheating the rights of a biological parent because of what their intention as a parent. And so if they have meaningfully abandoned their intent as a parent to practice their parental role, we can use that as private parties to terminate their rights in a step-parent adoption, or the state can be involved and look at their behavior either through abuse or neglect.
But let's take that forward, though.
Yes, sir.
These people they've been never married, but in any event, there's never been an adoption of this child by your client.
That's correct, Your Honor.
So even if they had married after the child was born, your client would be a step-parent.
That is correct, Your Honor.
And I think probably even though not married, she's been in that, at least that's the sort of role she's been in, correct? As a step-parent.
No, Your Honor.
You think that this agreement gives her full parental rights?
I think the actions of the parties give her full parental rights because she was involved, much like any other parent. Christy was involved in the conception of this child before the child was a twinkle in anyone's eye. And so for that reason... But
she never attempted to adopt her.
Well, Your Honor, with all due respect...
She relied on the possibility that her rights might someday be recognized.
Well, Your Honor, with all due respect, her rights were not recognized due to a prohibition that has been subsequently ruled as unconstitutional by Obergefell.
And I fully understand that.
And she was not able to adopt a child in Ohio for the first 1.5 years the parties lived there.
Right, but at some point she could have.
No, Your Honor, because as Justice Parental pointed out in WTJVEWR 721 Southern 2nd 723, forgive me because I did not put this in my brief, sure. She stated a court may grant a petition for the adoption of a child born in lawful wedlock only after both natural parents have consented. And the same thing exists for parents who have biological relations and out of wedlock. This goes on all the time across the state.
Unless parental rights are terminated.
Unless parental rights are terminated, that's right. So they can either do it by consent.
Or there's been a waiver by one of the parties whose rights are being terminated.
That's correct. So it says in certain instances, however, a court may excuse the required consent of a natural parent. One such instance is when a natural parent abandons his or her child. Statutory and case law allows the court to consider a natural father's, in that case, pre-birth conduct when making a determination of abandonment in an adoption proceeding. So in putative fathers' cases, we can look at their intention and behavior prior to the birth of a child from a one-night stand. I mean, my argument is, Your Honor, with all due respect, we're getting ridiculous results only because the parties are of the same sex. If this had been a situation where the parties had not been of the same sex and was opposite sex, and the genetic material used by Christy was actually matching hers, and in this case, I would argue that the fact that she purchased that material, no one purchases material of that sort without wanting to be involved in the end result.
I question, what happens if a similar type of agreement would have been between a man and a woman and the man was sterile?
He would have rights. He would inherit rights because under
Under what
DMT,
law?
VTMH,
Under what law?
Under what law?
DMT, VTMH, if they make an agreement, that's
So
a
this is the
surrogacy
case you
agreement.
didn't cite?
I'm sorry, Your
Is
Honor.
this the case you didn't cite?
That is a case that's cited.
Okay,
in the
no, no.
DMT
So
case.
explain to me why an individual that does not have a biological or adoptive legal guardian type right would be different if it were a man or a woman. I don't understand.
Because our surrogacy statute, Chapter 742, allows the parties to not have a biological connection, at least one party to not have a biological connection to the child that the surrogate is incubating for, gestating. And there's no necessity that the intended parents,
There's no surrogate, though, in the fact pattern I've stated.
there is a surrogate.
There's a donor.
There's a donor.
There's a donor.
Just
But
like
doesn't
here.
the statute say that under the statute, donation under the statute does not give the donor parental rights?
Well, I would argue there is a donor. There is a donor.
There's
and
a
that
donor.
Christy was
So
the, and
she-
Christy was the donor.
The person from
And it-
whom the,
I don't think it would be, I'm sorry, Your Honor, I
Christy
didn't
was
mean to
not the
interrupt.
donor. Christy was the procurer.
right.
And she donated that material that she purchased.
She was a procurer, though. It's not a biological donation. I think we can agree on that. And I think we can agree that she wasn't the birth mother, which again, if it was a birth mother using a donated egg and donated sperm, there wouldn't be a biological connection, but there would be a birth connection, which the cases seem to recognize. So you can say that she is a donor, but in fact, she is the procurer of the donated sperm.
And I understand exactly what you're
And
saying.
Justice Parente's case that you referred to, there is some language about, let me see if I can find it, that it's not the biological relationship, but the assumption of parental responsibilities. But the context of that case involved a birth mother who gave birth using the partner's egg and sperm. So there is, again, a factual context that seems to have tempered that one statement by Justice Pariente, and the rest of the opinion seems to walk back that statement to some degree, doesn't it?
No, Your Honor, I don't believe it does, because if you look at the lower court analysis and you also look at the appeals court analysis, you'll notice that the question hinged on whether or not the document that she had signed, the affidavit of donation of the ovum of the egg itself to her partner in order to procreate this child, constituted a severance of her rights to the child because she was using FDI approved.
Let's talk about that. The agreement here is a co-parenting agreement, right?
That's correct.
And it doesn't say anything about ongoing custody. It talks about basically shared parental responsibility, correct?
That's correct.
And there's a statement in there where there's actually multiple statements where there is a recognition that the right to contract is limited under state law.
That's correct.
And the current state of the law seems to be, for better or worse, that a contract like this is not sufficient to award custody or partial custody to a parent who is simply designated as a co-parent, not a custodial parent. Isn't that the current state of law, or you disagree with that?
I disagree with that. That's not
Okay,
the
so
state
give me the case that says that a co-parenting agreement is sufficient to demonstrate a waiver of custodial rights.
Well, just like in DMT, in the Roe v. Smith case in Ohio, the 2013 case in the Ohio Supreme Court,
What's the case site?
that is the 226 case. It is on the appellate. It's on the initial brief. Both the lower court, there's two cases on that, not to confuse the court. There's a Supreme Court case that was in 2013 and a appeals court case in 2015 involving both parties. But it was the Supreme Court case in Ohio that came first before the appellate court.
Is it the Supreme Court case you're talking about, Roll?
That's correct. And that's cited in the initial brief.
Okay, thank you.
Both of them. And in there, they did not have a written agreement, but the court looked at intent, just like it did in DMT, where Justice Parente looked at the intent of the parties beyond the written agreement that eschewed the rights of DMT from the child, which was what TMH was depending upon. And even though TMH had no biological connection to the child, the court ignored that and looked at the intended parties once again, because under gestational surrogacy in the Florida statutes, if there's not a biological connection to the surrogate, that takes away the right of the gestational surrogate to make a claim to the child that she gives birth to, or it compromises that claim, which is why the customary now, currently, when you're doing surrogacy, is to make sure that a separate ova is donated in those cases where you want to make sure that the gestational surrogate doesn't have a claim based on biology. And so it's customary now to use an ova from another woman when another woman is being the surrogate. But in the Roll case, they looked at the intention of the parties, and if you look at those cases, that case very carefully, and you'll see it in the appellate court, they hash it out, they lay it out much more clearly, but it almost matches this case exactly. There were 3 attempts, there was a purchase of genetic material. They looked at that, and there was an intention to be parents together, and it was only when they broke up that the other party relied on her biology alone in order to, and I forgot to say, I want to reserve 5 minutes for argument, sorry.
You got it.
And she wanted to make sure that she was a parent. And she argued once she had the right to see the child any longer.
Counsel,
Yes.
Roll, I was trying to find the language, and I found it in here. In Roll, the agreement that was established by testimony was a contractual relinquishment of sole custody and a grant of shared custody, correct?
That's correct.
And our agreement here is, does the shared custody language appear?
I don't believe so, Your Honor. I don't
So
think
is
it's that specific.
Is that a legitimate distinction between this case and your reliance on Roll?
I think co-parenting in itself, the words co-parenting infer that there's shared parenting and that there's a shared custody component to it. My client is not looking to, have the child custodially, and we don't even use that verbiage anymore in family law.
It
We
wants
have-
visitation rights and
We
to
don't-
be,
Shared parenting.
Yeah, we use
Shared-
time
Yes.
sharing.
Time sharing. rather
Yeah,
than-
we don't
and
use-
there's an offer even financial support
Right.
as
I mean,
well.
That's right, Your Honor. My
Yeah.
client's not just arguing to spend time with this child. This is not a Paramore case or a grandparent who had the child living with them for a long time, who was a Johnny-come-lately who came in well after the conception of the child. My client was involved with the intention to be a parent by both parties from the word go, from the mere idea of cognating this. And it seems a bit ridiculous for the state not to say it doesn't have a compelling interest to protect this child's interests. We're arguing about children, taken away from their children taken away from their parents and guardians at the border right now, and about how damaging it is for them. And we can't ignore that it's just as damaging for this child to have somebody that they see as a parent. Children don't walk around saying, well, can I see my birth certificate to determine whether or not you're really my parent? They go by what is facilitated to them in a social setting. This is your mama, this is your daddy, this is your grandma, this is your grandpa, this is your nana, this is your poppy, this is your aunt, this is your uncle, this is your cousin, by social recognition. And that's exactly what happened in this case. It's down in the trial record where this child was socially groomed to believe that Christy was a full and equal parent. And that's all Christy is arguing for. She wants all the rights, obligations, and banes of parenthood. She's waiting for him to turn 14 and not want to take out the trash, okay, because he wants to watch this show one more time. She's waiting for that. But she's being deprived of doing that, despite the promises and the effort she made to bring this child into this world. It's ironic that a gentleman who is not married to a mother, a birth mother, can have a one-night stand at a beer pong party and have more rights to a child just because of genetic material with no intent to parent. And we all can think of cases like that. And I know that you've heard cases like that, where people don't want to be parents or didn't act as parents and now suddenly want to be a parent because now somebody's going to escheat their right. Christy begs to be the parent to this child she's always intended to be, including making sure that he can depend on her financially, to make sure the state doesn't have to do so and be obligated to do so, which it has in the past, because Nicole has been able to and has applied for benefits because of the lack of recognition under the statutes of the parties' relationship. Christy doesn't want that for her son. She wants him to be able to depend on her and rely on her. She doesn't want him to have to be a ward of the state at some point if something happens to Nicole. When there's a viable individual who is willing to take that place, and the state should have a compelling interest in doing that, and shouldn't allow Nicole to hide behind this veil of privacy when she has clearly waived it through her actions, not just in writing, but through her actions. She understands that she has made Christy a full and equal parent to her, but she refuses to recognize it now. It's because she's upset with her. And the only thing that allows her to do it is the prejudice within our statutes and case law. And at some point, the judiciary has to act. Justice Justice in Wakeman in the dissent, he talked about that, about how...
Judge Van Nortwick,
No,
Van Nortwick.
Thank you, sorry.
whose position in his dissent, where actually it wasn't a dissent, if I recall, it was special concurrence.
Special concurring opinion, that's correct.
And he basically said, as you were saying, or seem to be saying right now, that the law doesn't support this position, but if only the legislature would act. And to this point, the legislature has not acted, correct?
That's correct, Your Honor.
So
And
you're not asking us to follow Judge Northcutt's special concurrence, you're asking us to disagree with it and say, there's enough here that the judiciary can act.
Well, I think that, I think I'm asking you to agree and disagree with it to a certain extent. I mean, you know, the justice actually he talked about the detrimental harm to a child psychologically, and that this was a really awful result for the children in that case, and that it could be psychologically harmful to them. But he also talked about the other argument was that there was no argument of detrimental harm to the child on the lower court level or anywhere within that record. And it was argued in this case. And we're arguing that there's detrimental harm to this child. And at that point, the court has the permission and purview to pierce the veil, the shield that Nicole has decided to hide behind, and say she has a right to privacy, and that allows her to damage her child, in effect.
Was there any finding that this child would be harmed by the court doing what it did? In fact, didn't the judge say that there was no showing of detriment to the child?
Well, the child court
Which is a
said...
factual determination, correct?
It's a factual determination. However, the judge specifically stated he didn't believe that inability to financially benefit from a parent was something that was in the child's best interest. But then we had the Simmons v. Perkins case come out after that Justice Parental again was talking about, that financial benefit of a parent to a child is in the child's best interest, which seems to contradict the lower court judge's ruling. And so I believe that also supports our argument.
There are a lot of things that could be in a child's best interest, the absence of which is not detrimental to the child. It's not harmful to the child. Isn't that a distinction that the law makes?
To some extent it does, Your Honor. However, Justice Parental said in the Simmons v. Perkins case that we further hold that the presumption is overcome when there's a clear and compelling reason based primarily on the child's best interest, okay, and that although the circuit court held an evidentiary hearing and found that the facts strongly indicate that allowing Perkins to have some involvement in the child's life would be in the child's best interest, to explain that a biological father may seek to establish his paternity even when both the mother and husband object, if common sense and reason are outraged, by applying the marital presumption to bar such an action on the particular facts of the case. And we believe that it's outrageous, it is an outrageous circumstance to allow Nicole to totally escheat Christy's rights when she is clearly waived by action and by writing her right to exclusively parent. I mean, to say, Your Honor, that this written agreement doesn't do it and her actions don't do it, I don't know how it was interesting that the case prior to this was a criminal case, because at some point somebody had to waive a right to be silent, or maybe didn't, but was offered the opportunity to do so, and you can do that by your actions, so I don't understand how you can't do that with a right to privacy. You know, if you can do it by a nod or an assent, if you can waive your right to be jailed indefinitely for an indefinite period of time until the end of your days, by merely speaking again after you've been read those rights, or saying, oh, it's okay, I'll talk to you, then why are we bending over backwards to allow Nicole to not waive her right to this privacy that she's supposed to be given, that she wears as that she garners around as a giant shield to keep all other comers in and out?
Let me ask you a question. By and large, and maybe completely, contracts involving the welfare of a child are not binding unless found, approved by court.
That's correct.
So what you're saying, you're not saying your client has the right to enforce this contract. I would assume, I think your client is saying that she has the right to get into court, to have a court determine whether this is in the best interest of the child.
That's correct. We believe that she's entitled to a best interest hearing, which was not what happened at the lower court, Judge Silberman.
Right, there was no standing, and so.
Because it was mainly adjudication based upon the standing of Christy to make the argument to begin with, and whether or not there was enough evidentiary fact, in a light that's best, alluded to on her side. However, as I read that order, it seems to me that the judge was relying heavily on the fact that her argument about her financial ability to care for this child and her relationship with the child wasn't, something that the court thought it could.
Hadn't got to that point.
It hadn't gotten to that point yet, right. And so he felt he was barred, the judge felt he was barred from having this hearing because of the PASIC ruling that you guys came out with prior, which also didn't argue detriment. It didn't make a lot of other arguments that we made in our case. It didn't talk about intention. It talked about de facto. She's not like a parent. She is a parent. She's, there's more than just a psychological connection here. It's not just with Christy. It's with her sister. It's with her mom and dad. It's with her cousins. This child knows an entire family on Christy's side, and he knows them to be family. In the social contracts that under the social constructs that we all understand family. And I think all of us understand what that means when you're totally estranged from your favorite aunt and uncle or your parent, to be ripped away like that can cause, egregious significant harm, which is something that we've been arguing for like at least the last 12 months in the media.
You're down to 5 minutes.
All right. Thank you, Your Honor.
Sure.
Good morning, Your Honors. May it please the court, counsel. My name is Stephanie Willis, appearing on behalf of the appellee, Nicole Springer. The first DCA in Wakeman v. Dixon, this court in Russell v. Passick, and the third DCA in De Los Milagros Castellat versus Pereira all have found that non-parents don't have standing to seek time sharing with children or custody with children. The Supreme Court of Florida in Von Eif found that there's a fundamental right of privacy that a biological parent has in determining how to raise their child, with whom that child has interactions. And in DMT versus TMH that opposing counsel was talking about earlier, that court specifically said that it's the biological connection between parent and child that gives right to an inchoate right to be a parent that may develop into a protected fundamental constitutional right based on the actions of the parent.
So was that, how do you square that statement with the statement earlier in the opinion that it is not the biological relationship per se, but the assumption of parental responsibilities, which is of constitutional significance?
The large majority of that case, as I recall, focused around the biological connection. One statement, randomly in the case, I don't think controls.
Or might your response be that biological connection alone is not enough, but the cases recognize that it is the bedrock foundation?
Correct, Your Honor.
And then beyond that, there has to be an assumption of parental responsibilities.
Right, so you have someone who is a biological parent, and then they have to still go on to show that they're caring for the child, they're around the child, they're supporting the child in order to get time sharing and rights and responsibilities that go along with that.
So how do you square the constitutional right of privacy with the constitutional right to enter into contracts, the well-established law as far as best interests of a child in having two parents, if possible, as opposed to one parent, and you have a willingness here of both parents financially supporting the child and raising the child as demonstrated by the contract. How do you square all that with what seems to be the court's language in multiple cases, that the right of privacy seems to hold an even higher position?
It's my understanding, based on the case law and our statutes, that the explicit right to privacy that you get under the Florida Constitution in Article 1, Section 23 is paramount to all of it. And the Von Eif Court and numerous other courts have said that it's such a high burden that they've never seen it overcome in cases where a non-parent is seeking time sharing with a child.
So in Judge Van Nortwick's concurrence, he suggested that legislative action is necessary. Could legislative action fix this problem? If the right of privacy has been interpreted the way it has, that a biological or birth parent seems to have all rights above and beyond any other pool of rights?
The legislature could certainly attempt to resolve the issue, but I think that in an attempt to do so, they would open a huge can of worms where, you know, we talked about the one-night stand earlier in a heterosexual couple. If that same person has the one-night stand, but the very next day enters into a loving relationship with someone who they want to get married to and carry on living and raising a child with, then why is it not that person's, prerogative to still hold the one-night stand accountable for that child? I mean, we have situations like this all the time, so I think that you would open up a huge can of worms on who was there when and who did what and how long were you there.
The legislature does venture into this area.
I'm sorry?
The legislature has ventured into this area at times. You know, the presumption of, between a married couple, right? When
Right.
a child is born to a marriage. The adoption statutes.
Right.
So
the
adoption, when a child has been in a step-parent adoption, the biological parent has no greater right or interest than the adoptive step-parent, correct?
Correct.
I think as Judge Silverman points out, sometimes it's kind of hard to reconcile, but at least in those situations, the legislature defines some rules to the game.
Right, exactly. And they say, you can have the biological connection, or you can marry the person before they give birth to the child, or you can do an adoption after the birth of the child, whether it be a step-parent adoption or a second-parent adoption if you're not married. So there are a lot of different options for people to gain rights to children, and Christy, frankly, didn't even try to do any of them, and then comes back after the fact and says, well, now I'd like you to just go backwards in time and do something for me that I never did for myself.
Well, but she may well have thought that she had done what she needed to do.
Well, as
did-
you all
did
pointed
it.
out in the four corners of the document, though, it specifically says, Nicole will be the only parent to this child.
Judge Hellinger indicated in his order that he wasn't aware of any case that would find essentially the right of privacy to be waivable. Why couldn't it be waived, like any other constitutional right?
I mean, I suppose...
He didn't reach the factual determinations. He basically said, I don't see any case that allows waiver, but isn't any constitutional right waivable?
In theory, I would assume that it would be. If this agreement said, I hereby waive all of my rights to be the only parent to this child, but it doesn't even come close to saying that. It specifically says, I, Nicole, will be the only parent to this child.
Well, it says she'll be the only mother.
Right.
And everything else is consistent with allowing everything to be jointly determined. I mean, it even says, even if we separate, we're going to make joint decisions to the extent that we can. And it doesn't say, if I recall correctly, the parenting agreement doesn't have a provision that if we can't agree, I'm the mom and I'm going to make the decision. And so, as long as we agree, it's but if we don't agree, it's no longer co-parenting. It doesn't say that.
Well, I think it says that by virtue of the fact that it says that it's controlled by state law, and Florida's state law does not allow for co-parenting agreements to be valid, and this co-parenting agreement was entered into before the child was even born. So even if it were to be such a case in Florida that it allowed for it, it was before the birth of the child, which, as you all know, you can't adopt, you can't gain rights to a child you're not biologically related to prior to the birth.
You can't give up parental rights before the child.
Exactly.
If we were to conclude, as the appellant argues, that Ohio law would permit a co-parenting agreement, and I'm not suggesting that I've reached that conclusion, but if it did, would Florida be within its rights to not enforce that Ohio agreement if it were enforceable in Ohio, and an effort is then brought to enforce it in Florida by Florida residents?
There was actually a recent case that I unfortunately do not remember the name of, Your Honors, where Florida specifically looked at an out-of-state agreement that was entered into. I believe it was a marital settlement agreement or something, where Florida said because it is Florida law and it is it's such a specific requirement of Florida that we're not going to follow it.
So
and I don't.
In terms of a conflict of laws.
Exactly. When they said there's a conflict of laws, I think it was Georgia that allowed for an agreement between the parties. Florida said it's not the way that we do things. It's not
policy.
allowable under public policy. Yes, Your Honor. So they failed to enforce it. It's my contention, Your Honors, that the right to privacy is supreme. The Supreme Court of Florida, the Supreme Court of the United States in Brookhart v. Janus said that there's a presumption against the waiver of constitutional rights, and the party claiming waiver must clearly establish that the waiver was intentional. I don't think that that bar has been met in this case. In
Well,
fact,
we don't know that because the trial court didn't rule on that.
correct.
But then there would be the other question of whether what's waived, you can't revoke the waiver.
Right.
I mean, that begs the question.
Exactly, and so in some of the grandparents' rights cases where they, one of the mothers gave the child over, I think it was Troxel, to the paternal grandparents for a period of time so she could work and go to school, she was able to take that back and decide that, yes, I let you have the child for a period of time, but I'm now taking it back. And as the biological parent and the only parent with any legal rights to the child, she was allowed to do so, and the court upheld that.
It's interesting, though, the agreement in paragraph 11 says that we agree if any court finds any portion of this contract illegal or otherwise unenforceable, the rest of the contract is still valid and enforced, which I don't want to get too far afield, but it seems to suggest that perhaps she didn't have the right to rescind her waiver to the extent there was a waiver.
Right.
But that wasn't litigated.
But that would be a contractual matter.
Right.
But in terms of whether one can waive a constitutional right, even a fundamental one, I think that's what the right of privacy is deemed to be. Whether you could then revoke the waiver.
Exactly. And it's such a high bar that, I mean, without even
So if
specifically
you
stating that you've...
waived it in a contract that said you couldn't rescind the contract, could you still revoke the waiver?
I would argue
on a
yes.
constitutional basis?
I would argue yes.
You would. That's your son.
Of course. Do your honors have any other questions specifically about the merits of the case? If not, I wanted to briefly address attorney's fees. The second DCA and BK versus SDC said that appellate attorney's fees was appropriate despite the absence of such express language where a party seeks to declare rights regarding parentage, support, and time sharing. Nicole has already spent a year dealing with this and having to have counsel show up in order to, I mean, the law is clear and unambiguous. Everyone knew going into this that there were no parental rights that Christy was able to seek. This court also, second DCA here in Bassett versus Standard Fire Insurance, said that Chapter 86 does not act independently. It allows for other statutes, attorney's fees provisions to provide the prevailing statutory authorization as applicable. Rosen specifically says that any determination regarding an appropriate award of attorney's fees in a proceedings for dissolution of marriage or child custody begins with Section 61.16 of the Florida statutes. And that would be the area in which if Christy were able to get rights, she would receive them through Chapter 61 or 742, but 742 only applies to men. It's not fair to my client to have to bear the burden when...
This is an agreement to declare rights under a contract. and the contract does not have a fee provision. Does that change the analysis for us?
I don't believe so, Your Honor.
I mean, it's not an effort to enforce rights under Chapter 61. It's an effort to declare rights under a written contract.
I believe they actually cited Chapter 86 as the declaratory relief, Your Honor. It was not specifically to determine the rights under.
Does not have a provision for attorney's fees, does it?
It does not, but as I was saying, that this court in BK versus SDC and Bessette versus Standard Fire Insurance allowed for attorney's fees through Chapter 86 proceedings based on the underlying statutes that they would have applied.
The practical import of the request for declaration of rights.
Exactly.
But those cases did not involve a contract.
Bassett was granting attorney's fees to prevailing party in declaratory judgment action based on an underlying statute. I think that was a PI case.
I may be wrong. My recollection is there is no case that authorizes fees under Chapter 61 when the lawsuit is essentially brought outside of Chapter 61 but is brought under a contractual right.
I believe, I don't know about the contractual portion, but BK versus SDC did award attorney's fees for actions seeking to establish paternity under Chapter 86. So it's, if you can do it for 742 or 61.
But this isn't an effort to establish paternity.
Well, they're trying to usurp
It's an effort to
the rights.
establish custody under an, I mean, I'm actually trying to flesh this out a little bit.
I understand.
It's an action to determine, I'll call it custody, even though it says co-parenting, under an agreement, not by a statutory entitlement, or the cases that interpret the statutes dealing with custodial arrangements.
I think even the titles of the amended petition was paternity, time sharing, custody, parental rights. Yeah, I don't think that that was their main argument, was the
So the
agreement.
argument then is that there's no standing to proceed forth, but there is attorney's fees for moving forth with the very thing that the court didn't have standing to decide.
Right.
That's bizarre to me. It seems like you can't have it both ways. You know, the contract may not apply to the co-parenting rights. We don't know that yet. We haven't discussed it, the panel here, but it seems odd that you could have it both ways and charge Christy with these attorney's fees on top of it all. Should have been included in the contract, is what I would say.
Also argued, though, that there's a frivolousness to it.
Right, exactly.
There are sanctions that could be brought forth in appropriate motions.
The trial court was not asked to award fees, was it?
I did file a 57105 and was specifically told not to set it for hearing, so.
Okay.
It's for the trial court to decide.
All right.
But yeah, to address what your concerns were with having it both ways, that's my argument, is what they're trying to do. They're trying to say 61 doesn't give me rights, 742 doesn't give me rights, but I want to use some combination thereof
I understand.
through 86. So,
Thank you, counsel.
thank you very much, Your Honors.
Your Honor, Your Honors, I believe that counsel wants to hide behind the contract to some extent, although it makes it clear that if a court of law finds any provision of the agreement to be unconstitutional or not valid, then the rest of the agreement stands as what the contract says. So it appears that Nicole and Christy assumed that at some point there may necessitate a court action. And Chapter 86 itself allows for relief to be sought when a party may have something that's actionable and meritable, but there's a lack of basis within the statutes of the case law for somebody to take a direct route. As counsel says, it's like paternity, the Chapter 742, which arguably and ironically enough is titled Determination of Parentage. However, that word parentage only appears in the title. It doesn't appear anywhere else in the statute. And what's particularly interesting is that, you know, in DMTV TMH was, you want to talk about, let's talk about the intent of the statute. I think when the legislature passed a statute that said that the birth mother who has a child out of wedlock is the only legal guardian of a child, never predicted that a birth mother would give birth to a child that she intended to be a parent to who would not be biologically related. That was done because we can make sure, we felt certain at the time that statute was passed, that we would always know who mom was. And there's other social contracts, you know, certain religions make mothers responsible for the edification of children in religious sets because of the fact that we can be sure that we know where the children came from, because she's the only one there at birth, obviously.
But there's a whole host of statutes we could go look at and say, well, you know, that statute was passed in 1927 and this is 2019, so the legislature could not have anticipated what's going on now, so we get to disregard the statute?
Well, that's what they did in DMTV TMH.
Or we get to say the legislature should revisit this, like Judge Hellinger said.
Right, but Judge Parental didn't even make that inference in her opinion. She didn't even talk about the fact that at the time, you know, in fact, it was kind of unique because they were talking about at the time that the surrogacy statute had been drafted in 1993. Nobody thought about somebody transferring over, but she ignored the question that begged in that case about, well, then why are we allowing a statute that also didn't predict this type of situation to stand as a rule to give both parties parents, because she was looking at intent.
But all the statutes have existed during a time when purely contracts for parental rights have not withstood the law.
That's correct.
And the legislature, of course, is aware of this.
That's correct.
So
Doesn't mean they're going to change it.
How are we, wouldn't we be legislating if we said, oh, well, now they have to be on?
Well, Your Honor, it didn't keep the judiciary from ruling that the ban on same-sex adoption was unconstitutional.
Unconstitutional.
Based upon a child's...
But it's not a matter of contract law, it's a matter of constitutional law.
Right, based on due process and equal protection, which we also argued here.
Well, I would think that would be what you have to argue here.
That's correct. We are arguing that. We didn't lean heavily on the contract itself. The contract, we think, is part of the proof of, that's part of the proof of the waiver.
What we have, though, is there's no instance in which this contract could bind the courts, whatever the parties' marital or gender situation would be.
That's correct, Your Honor, and that's why I wasn't arguing, contract law in my appellate brief. I was arguing about intention. It's about more than just biology. I mean, the court system, as I explained before, looks at intent all the time. And, counsel was talking about parents having a right, to children. I mean, the guy at the beer pong party still has a right, whether he moves on in another relation or not, to pursue his relationship with the child born from that one-night stand. And nothing inures him or impedes him from doing so. And if he subsequently decides to marry the birth mother, he automatically has guardianship rights. He doesn't have to go spend loads of money in a court system to have those rights recognized. He doesn't have to fight for it. And that's the other part of the equal protection part here, because there is no avenue for Christy to take. And for them to argue that she could have just adopted when that requires consent, she could have just married when that requires consent, and marriage alone wasn't going to allow her to effectively be a parent either. It would have had she been a father instead of a mother. If she had the biological material she donated matched hers. I mean, and that's why we say this is a violation of her equal protection and due process rights and the child's, because just because he has two same-sex parents, he's at risk of being made a ward of the state if something happens to Nicole. I go through this in my practice all the time with these families. We do confirmatory adoptions when people have children this way, even if they're on the birth certificates, because the birth certificates are only administrative documents that record social events. They're not things, they create a rebuttable presumption, and it says it right there in the state statute. In fact, the state statute seems to suggest, if you read it closely, that after 60 days, it's irrebuttable unless there's good cause to be shown. But we know that since that's been drafted, we can use a DNA test to make sure somebody's biologically connected, which Justice Parental discussed in the Simmons v. Perkins case. So at any point, if a gentleman suspects early on in the matter, he can ask for a scientific, test, even if even if he's already signed that affidavit of paternity and it's past 60 days. We also don't punish anybody for signing an affidavit of paternity when they know they're not the child's father, except for when they do so in order to be eligible for state benefits, because state has compelling interest to make sure somebody's not ripping them off.
You're beyond your rebuttal time.
Thank you, Your Honor.
Thank you both very much.
Thank you, Your Honor.